Good afternoon and welcome. We are very pleased that you're able to be with us this afternoon for our webinar on a topic that is definitely the topic of the hour and which seems to be in a constant state of flux and evolution on a week-to-week and also a day-to-day basis. COVID-19, vaccinations, the workplace, and accommodations. We spoke on this at our seminar just a couple of months ago, and at that point, we were still awaiting the OSHA ETS, Emergency Temporary Standard, and the CMS vaccine rule, and we were also awaiting further clarification on the federal contractor and subcontractor mandate for vaccines. And oh, what a couple of months can do, yes? Since then, each of these mandates, of course, were issued and clarified in the instance of the federal contractors and subcontractors mandate. And we all scrambled to put in place policies and processes to meet the respective deadlines. And then in a matter of weeks, it seemed, the mandates were subject to some form of federal injunction and then a nationwide injunction. And then, of course, just as of yesterday, the injunction was lifted for the CMS mandate for a number of states, including Minnesota and Wisconsin. We're still waiting for clarification from the Centers for Medicare and Medicaid Services, the CMS, as to what it's going to do in light of the partial lifting of the injunction. And we'll fill you in on this development and what it means in practical terms during our presentation this afternoon. Suffice it to say, we are in an ever-changing situation with respect to federal vaccine mandates. It's important to note that these injunctions, while they're still in effect, they do not prevent employers from issuing or from continuing to implement vaccination policies themselves, provided that these policies are drafted and administered in accordance with federal, state, and local human rights laws and other laws, and provided that they do not conflict with the laws in the number of states that restrict vaccination policies and mandates. The members of our audience this afternoon are, we expect, in various different stages of decision-making with respect to the whole vaccine issue. Some of our clients have already implemented mandatory vaccination policies and processes in anticipation of the federal mandates, or simply on their own, and have decided to leave those policies and processes in place. Others have put their vaccine mandate preparation on hold, awaiting the court challenges and what's going to happen there. And still others may be considering whether they should or wish to issue some form of mandatory vaccine policy due to the rapid spread of the Delta and Omicron variants recently, regardless of whether federal mandates survive or not. Wherever you are in the decision-making or thought process with respect to mandates, we hope that our comments are of interest to you and of practical use to you. I am joined today by three of my colleagues. Sean Nagle is a senior associate in our firm's health law group. Sean assists healthcare clients with transactional matters, but also with regulatory compliance, and has assisted many of our healthcare clients implement and navigate COVID vaccination programs. David Waytz is a shareholder in our employment and labor group, and he focuses on advising clients on all aspects of employment law. Specific to our topic this afternoon, David has assisted many clients implement and navigate COVID vaccine programs and enjoys working with clients to ensure that their workforce is safe and productive. Olivia Norton is a senior associate in our employment and labor group. She is in our Des Moines office, and she is both a litigator and an advice lawyer. I'm a shareholder in our employment and labor group, and like David, I advise clients on all aspects of employment law. And specific to our topic today, I regularly advise clients on COVID-19 strategies and in implementing and navigating COVID-19 vaccination programs. Turning to our agenda for today, we will provide you with an overview of the 3 federal mandates for context purposes. Again, we're in a continuing state of flux with respect to these mandates. We are all seeking clarity, but we may not have absolute clarity for quite some time. It's simply the way of the world these days. We will then, after a discussion of the mandates, provide an overview of a legally compliant vaccination policy, compliant specifically with existing federal and state human rights and privacy and other laws. Please note in this regard that you will want to have your policies reviewed by your counsel. And we advise, even if you've already issued a policy, if your counsel has not reviewed it, we urge you to send it to your counsel for a quick legal review, particularly if any of these injunctions end up being lifted and you're subject to the CMS mandate, the OSHA ETS, or the federal contractor, subcontractor mandate, because there are bells and whistles in each of these mandates and rules that need to go into your policy. We will also discuss the various exemptions that come into play and must be in place under each of these mandates or under voluntary policies that you issue. And in that context, we'll talk about if an exemption is deemed to apply, the evaluation of potential reasonable accommodation measures in relation to those exemptions. Following that discussion, we will take questions. Very quickly, a few housekeeping items before we jump in. At the bottom of your screen, you will see a toolbar with a variety of engagement tools. These tools are resizable and movable, so you can do what you need to do to maximize the utility of your desktop space. We encourage you to submit any questions through the Q&A tool, and we will address those questions at the end of our presentation today. Under resources, you will find a copy of today's slides and additional links relevant to this program. Our live webcast attendees will receive a follow-up email after our presentation today with continuing education details. And if you need a certificate of attendance, you can download it from the continuing education tool. This program is being recorded today, and you will receive a notification email with the on-demand version after the presentation. At the end of our webinar, our presentation, we would invite you to take a few minutes to complete our survey. This can be accessed through the survey tool at the bottom of your screen. And you should also see a pop-up for it at the conclusion of the webinar. Finally, if you have any technical difficulties, try refreshing your screen by hitting F5. And you can also click the help tool for answers to common questions. Without further ado, Sean will start us off with a discussion of the CMS mandate. David will then cover the federal contractor subcontractor mandate. Olivia will cover the OSHA ETS. And then we'll move to our discussion of policies, exemptions, and reasonable accommodation. Sean, you are up.
Thanks, Anne. Good afternoon, everyone. I'm going to be discussing the Centers for Medicare and Medicaid Services COVID-19 vaccine mandate, something that has occupied a lot of my time for the past month and a half, with many of our clients wondering whether and how it applies to them. To begin, I'd like to place the CMS mandate in context. On September 9th, President Biden gave a speech in which he announced a 6-pronged national strategy to combat COVID-19, one of which is getting more people vaccinated. And the CMS mandate is one of 4 federal mandates that were announced in this speech. With respect to the CMS mandate, President Biden said, if you're seeking care at a health facility, you should be able to know that the people treating you are vaccinated. Simple, straightforward, period. Unfortunately for the president, injunctions by multiple federal courts have caused implementation of the CMS mandate to be anything but simple and straightforward. Following the president's speech on September 9th, CMS issued a press release announcing that it was developing an interim final rule, or IFR, to implement the CMS mandate. And this IFR was published in the Federal Register on November 5th. While President Biden's speech referred more generally to workers at healthcare facilities, The CMS mandate requires vaccination of staff at facilities subject to conditions of participation and conditions for coverage, which are health and safety standards that certain healthcare organizations must meet in order to participate in Medicare and Medicaid. Before touching on the details of the CMS mandate, here are the highlights. The mandate is expected to apply to over 17 million individuals at over 76,000 healthcare facilities. The original implementation deadline for Phase 1 of the regulation was December 6th of this year. Phase 1 requires all policies and procedures to be in place and for staff to have received at least their first dose of vaccine. The original deadline for Phase 2, which essentially builds on Phase 1 by requiring full vaccination, is January 4th of 2022. The reason I'm referring to original implementation deadlines is that as of November 30th, federal courts temporarily halted implementation and enforcement of the mandate in all 50 states, which created a lot of uncertainty regarding when or if the mandate would go into effect. As I'll discuss in more detail later in my presentation, the situation was further complicated yesterday when the Fifth Circuit Court of Appeals lifted the nationwide injunction in about half of the 50 states. Even though it remains unclear whether, when, or where it will go into effect, I'm going to proceed with a brief overview of the CMS mandate. Now, what follows is an abbreviated version of a presentation I gave last week in our health law webinar. So I encourage you to watch that webinar if you'd like a deeper dive into the details of the CMS mandate. That webinar is available on demand for no charge, and you can access it via the hyperlink here on slide 6 or on the resources tab that should appear on your screen. The threshold question is, what facilities are covered by the CMS mandate? Despite lots of overbroad language on this point in the popular press, the CMS mandate does not apply to all healthcare facilities or even to all healthcare facilities that accept Medicare or Medicaid. The mandate only applies to certain Medicare and Medicaid certified facilities that are subject to conditions of participation or conditions for coverage. These range from large facilities like hospitals and ambulatory surgical centers to organizations that provide care in the patient's home. In terms of notable exclusions, your typical physician office is not subject to the mandate because it is not subject to conditions of participation or conditions for coverage, even though it may accept Medicare or Medicaid patients. If your organization or facility is subject to the CMS mandate, there are at a high level 3 key things to understand. First, covered facilities are required to establish written policies and procedures to ensure that all staff, a key defined term I'll discuss in a moment, are vaccinated. Second, the CMS mandate does permit medical and religious exemptions to the extent required by federal law. And third, testing is not an alternative to vaccination under the CMS mandate. This is a key distinction between the CMS mandate and the OSHA mandate on employers with 100 or more employees. The next threshold question is what staff are covered by the CMS mandate. The key point here is that staff is defined very broadly and extends far beyond employees and other personnel in a patient-facing role. With limited exceptions, the definition of staff captures any individual providing any services for the covered facility and/or its patients. In addition to clinicians, think administrative staff, housekeeping, maintenance staff, etc. The only exclusions are fully remote staff who do not have any direct contact with patients or other staff, and one-off vendors and others who infrequently provide ad hoc non-healthcare services. For details on the required policies and procedures that covered facilities need to adopt, I'm going to refer you back to the health law webinar, but I will briefly touch on a few things that have come up with clients. First, facilities must implement additional precautions for all staff who are not fully vaccinated. There are 2 things to note here. First, staff who receive exemptions from vaccination will need to comply with additional precautions. The CMS mandate doesn't spell out what these precautions must be, but some combination of masking, distancing, and regular testing would presumably be appropriate. Second, because an individual is not considered fully vaccinated until 14 days after receiving a second dose, they will remain subject to such additional precautions until the end of this waiting period. Second, one of the few specific requirements in the CMS mandate with respect to medical exemptions is that the doctors signing the exemption request form must specify which vaccines are contraindicated. We've seen several clients repurposing medical exemption forms that predate the CMS mandate. They've often missed this. Before moving on, I'll offer one other practical tip when it comes to repurposing mandatory vaccination policies and exemption forms that predate the CMS mandate. While the CMS mandate applies to all staff, many pre-existing documents will naturally refer to employees. You want to be sure to use the appropriate terminology when preparing policies and exemption forms for purposes of compliance with the CMS mandate. With respect to the potential consequences of noncompliance, CMS has stated that its goal is to bring healthcare facilities into compliance. It has also warned that it will not hesitate to use its full enforcement authority, including possible termination from Medicare and Medicaid if a facility does not comply. Finally, as I stated at the beginning of my presentation, the CMS mandate has been hit with injunctions from multiple federal courts. The mandate was halted in 10 states on November 29th by U.S. District Court Judge in Missouri, and in the rest of the country on November 30th by U.S. District Court Judge in Louisiana. The Missouri court was sympathetic to plaintiff arguments that CMS exceeded its authority, that CMS improperly bypassed notice and comment requirements, and that the mandate is arbitrary and capricious. While acknowledging that Congress provided CMS with general authority to enact regulations for the administration of Medicare and Medicaid and the health and safety of recipients, the court found that the extraordinary nature of the CMS mandate required clear authorization from Congress. Notice and comment requirements refer to procedures that ordinarily require notice and a comment period before a rule like this one takes effect. The court found that the plaintiffs are likely to succeed in their argument that CMS did not have good cause to bypass the notice and comment requirements. And finally, the court found that the mandate is arbitrary and capricious for several reasons, including that CMS lacked evidence showing the effectiveness of vaccination at reducing the spread of COVID in the covered healthcare facilities, that CMS failed to consider or improperly rejected alternatives to a vaccine mandate, such as regular testing. The mandate is overbroad in that it applies equally to a wide variety of healthcare facility types, including those for young patients who are at less risk from COVID and those for the elderly. That the government did not adequately explain its change of course from a policy of encouraging vaccination to one of mandation, and that it did not adequately consider the possible negative effects on the healthcare system of imposing the mandate, such as exacerbating staff shortages. The Missouri court's injunction, which again relates to 10 states, remains in effect and is currently on appeal in the 8th Circuit. It will likely remain in effect for weeks or months, as both the District Court and the Circuit Court denied the administration's request for a stay on the injunction while the appeal is going forward. As I mentioned, the day after the Missouri court halted the CMS mandate in 10 states, a Louisiana judge issued a similar preliminary injunction that applied to the rest of the country, which was interesting because the judge could have limited the injunction to the 14 states that were actually plaintiffs in that case. Until yesterday, it looked like the Louisiana court's injunction was going to remain in place for a long time while the case was on appeal in the 5th Circuit. As with the Missouri injunction, the Louisiana District Court denied the administration's request for a stay on the injunction while the appeal is ongoing. However, the big news yesterday was that the 5th Circuit issued an order denying the administration's request for a stay with respect to the 14 plaintiff states, but granting a stay with respect to all other jurisdictions covered by the district court's injunction. This order means that there is no longer a judicial barrier to implementation and enforcement of the CMS vaccine mandate in 26 states. And actually, I need to modify that statement with even more recent news that broke this morning. Shortly after yesterday's order partially lifting the nationwide injunction, a U.S. District Court judge in Texas issued a preliminary injunction that applies to the state of Texas. So this means that the CMS mandate is currently enjoined in 25 states. As of this morning, CMS had not yet issued a statement in response to these developments, and we don't know whether CMS will proceed with implementing the mandate in the jurisdictions where the injunction has been lifted. The last official word from CMS on the matter was a December 2nd statement that it had suspended activities related to the implementation and enforcement of the mandate pending future developments in the litigation. Until we receive additional guidance from CMS, I would ignore any headlines claiming that the mandate is now in place or moving forward in half of the country. We simply don't know. And finally, this slide shows where the CMS mandate is currently enjoined and where it is not enjoined, except that now Texas should be moved into the enjoined list. To conclude, because things are changing so rapidly and we simply don't know whether, when, or where the CMS mandate will go into effect, we urge clients to continue to prepare themselves for the need to comply with the mandate, potentially on very short notice. And with that, I'll hand things over to David.
Thanks, Sean. The second major mandate that employers may need to deal with is a mandate for federal contractors and subcontractors. This executive order had a number of requirements. The one I'm going to focus on is the requirement of mandatory vaccination for covered employees on covered contracts and subcontracts. Like the CMS mandate, there's no testing option. This was an incredibly confusing executive order, and the analysis was sort of all over the place. The goal here with this brief presentation is just to make it a bit simpler and provide a bit of practical context. As written, the mandate has been interpreted to only apply to covered contracts, which are defined as contracts for services or contracts above the simplified acquisition threshold, whatever that means, which is $250,000. So contracts for products alone or contracts for under $250,000, they're not required to have mandatory vaccination. However, and this is a really important point, the executive order encouraged all government agencies to include mandatory vaccination provisions in any contract, whether it's covered or not. And that's practically what we've seen. So agencies are pushing out mandatory vaccination provisions, and subcontractors are passing it down. As a practical tip, if you're an employer that has federal contracts or subcontracts, it may be best practice not to try and suss out whether it's technically a covered contract or not. It may not matter. You may have a contractor pass that provision down to you because it's just good business. They don't want to push back. As I said before, this mandate only applies to covered employees. This is an incredibly broad definition here, and I'm actually going to read it for you. A covered employee means any full-time or part-time employee of a covered contractor working on or in connection with a covered contract or working at a covered contractor workplace. This includes employees of covered contractors who are not themselves working on or in connection with a covered contract. That's really, really broad. So it doesn't just apply to employees that are working to directly provide the service. It could be HR folks who are handling HR matters for employees who are providing the services. It could be administrative and payroll folks. It could be folks who have no connection to the contract, but they happen to be working at a covered contractor workplace. Out of all my clients that are dealing with this issue, they've all taken one path, and that's the path of least resistance. They're not going to try and fight whether or not somebody's a covered employee or not. That's just too difficult, and there's not enough guidance to figure it out. So with this broad definition, they're just taking the position, and I think it's a good one. We're just going to mandate vaccines for all employees. All right, so I talked about what the law would require. Like the CMS mandate, this contractor mandate is currently enjoined nationwide, unless things changed in the last, 30 minutes. They could have. I don't really know the time frame for when a decision will be had on this mandate, whether the injunction will stay in place, whether it will be completely overturned permanently. But again, practically speaking, what happened is when the mandate was first announced, agencies and contractors started flowing down these provisions. So while the injunction means the federal government's not going to be able to take any action and won't take any action to enforce the provision under this executive order, you're still going to have these contractual provisions in there, and it puts you in sort of a pickle. So whether or not the injunction goes back into play, you still may have contractual requirements that your customers have flown down to you. So it may be best practice to keep going and move forward with the mandate in the event you get these provisions, or in the event the injunction is lifted. And now Olivia is going to present on the OSHA ETS.
Thanks, David. So moving on now to the third and final federal vaccine mandate, the OSHA Emergency Temporary Standard, or ETS, which I'll discuss in a little more detail, starting with some background information, then getting into a high-level overview of the ETS requirements, as well as its current status. So as part of the President's COVID plan, which was announced in September, and which Sean touched on earlier, OSHA was charged with developing an ETS that requires employers with 100 or more employees to mandate vaccination or undergo weekly COVID testing. So under the Occupational Safety and Health Act, OSHA can implement an ETS and skip the normal rulemaking process if employees are exposed to grave danger and an ETS is necessary to protect employees from that danger. An ETS expires after 6 months, and it can be extended if OSHA implements a permanent rule during that time. So OSHA historically has implemented ETSs very sparingly. It has issued only 10 total in its history. 6 of those were challenged in court, and only 1 of them survived. So the track record for survival of these emergency temporary standards is not very high. The COVID ETS that's relevant here was published in the Federal Register on November 5th, which is when it became effective. So under the COVID ETS, employers are required to comply if they have 100 or more employees at any time while the ETS is in effect. So if an employer reaches 100 employees sometime after the ETS became effective, they must comply with it for the remainder of the ETS's duration. This ETS is different than the other 2 vaccine mandates that we discussed earlier, in that it allows employers to choose between implementing a mandatory vaccination policy or a policy requiring vaccination or weekly testing plus masking. So these requirements don't apply to certain workers, and those workers are people that work 100% remotely, workers who work outside 100% of the time, or employees who work alone in the workplace. Under the ETS, employers must provide up to 4 hours of paid time off per dose for employees to receive each of their primary vaccination doses. Employers are also required to provide reasonable time off and paid sick leave for employees to recover from any side effects experienced following each primary vaccination dose. These requirements for time off apply only to the primary vaccination doses and not to boosters. The ETS also explicitly preempts any contradictory state and local laws, such as those in Montana and Texas that ban vaccine mandates. In terms of compliance dates, originally December 6th was the key date for compliance, except for the testing requirement, which was to take effect on January 4th. As I'll get into a little more, given the current hold on the mandate, these compliance dates are obviously no longer in effect. So immediately after the ETS was issued, lawsuits were filed in circuit courts across the country. On November 6th, the Fifth Circuit issued an initial temporary stay, which was extended by an order that it issued on November 12th. So this order on November 12th enjoined OSHA from enforcing the ETS nationwide. All of the cases across the country challenging the ETS have now been consolidated, and they will be heard by the Sixth Circuit, who was selected pursuant to a lottery system. There are a variety of bases for these legal challenges. One argument that challengers are making is that the ETS exceeds OSHA's statutory authority. As I mentioned a few minutes ago, in order to have authority to issue an ETS, employees must be exposed to grave danger, and an ETS must be necessary to protect employees from that danger. So challengers here are arguing that COVID ETS does not meet the standard because OSHA hasn't shown that COVID-19 qualifies as a grave danger, or that the ETS is necessary to protect employees from it. The 100 employee threshold has also served as the basis for legal challenges. The argument here is that the ETS is under-inclusive because it does not apply to employers with 99 or fewer employees who are exposed to the same danger from COVID as employees who work for larger employers. At the same time, challengers are arguing that the ETS is overbroad because it applies equally to all workplaces, regardless of working conditions and risk factors for transmission. The Fifth Circuit, in its order enjoining the ETS, criticized the ETS for failing to account for differences in different workplaces. Constitutional concerns have also served as a third basis for legal challenges. So where do we stand today? OSHA has currently suspended enforcement of the ETS pursuant to the Fifth Circuit order. In the meantime, on November 23rd, the government filed an emergency motion with the Sixth Circuit to dissolve the Fifth Circuit stay. Both sides have now submitted briefs on the issue. I think briefing ended on December 10th. And so we are awaiting the Sixth Circuit's ruling, which could really come at any time. So the Sixth Circuit may decide to either uphold the stay, in which case enforcement of the ETS will continue to be suspended, or it may dissolve the stay, in which case the ETS may go back into effect. In either case, the initial compliance deadlines have already passed and won't take effect. So stay tuned and keep an eye out for a ruling from the Sixth Circuit. Now I will turn it back over to David, who will talk to you about implementing your vaccine policy.
So you've decided to take the plunge. Maybe you're a federal contractor getting ahead of the curve. Maybe you've just decided it's the right thing to do. And I think you're in good company. I'd say an increasing number of employers have implemented mandates with a lot of success. And so if you're just getting started, the first thing you want to have is a really dynamite written policy. It should explain first and foremost why you're doing it. We're doing it because we may be subject to a contractual requirement. We're doing it to keep people safe. We're doing it because of Delta or Omicron. The purpose statement is going to be really important, not only to communicate the why you're doing it, but during the accommodation process, when you're having to explain to employees why you may be able to accommodate people or why you may not be able to accommodate people, it's important to be able to go back to that purpose statement and say, this is why it's important, or this is why we can't accommodate you. So really, really important to have the why, along with the nuts and bolts, the things like deadlines and processes and what fully vaccinated means. Along with that why statement and the other content, you're going to have a good provision about how employees can request exemptions for religious or medical conditions. And as part and parcel of that process, you're going to consider legal requirements, as you see on the slide. And what we mean by that is you're going to have a policy that's compliant with the law. So by having a process for requesting exemptions, you're showing that you respect human rights laws or the Americans with Disability Act. To the extent federal vaccine mandates are in place at the time you roll out the policy, you want to make sure you comply with those mandates. Like Sean was saying, the distinction between employees and staff. At the same time, presently now, I wouldn't necessarily have a why statement saying, we are doing this because of OSHA ETS, because you're going to get a lot of questions say, well, I thought OSHA ETS was paused. So you could say something like, because it may be in play as part of the why. But you're going to consider those vaccine mandates. And then also, really importantly, you're going to take into account state laws that may preclude you from having a vaccine mandate. And so you want to have some good lawyerly language in there that says something like, unless a contradictory law applies, we're mandating vaccines. Okay. So you have that written policy, and at the same time, you're developing your accommodation process. You're going to have forms for religious exemptions, forms for medical exemptions that note that you can request information from a healthcare provider or a clergy person in certain circumstances. And I wouldn't recommend having the forms rolled out with the written policy, but you want to have them in your pocket in the event somebody requests an exemption. You're also going to be thinking about, how are we going to handle accommodations? I'd say for most clients, the most efficient way of handling it is having HR and legal serve as sort of a central clearinghouse, and they can always go to the direct supervisors on the line if they have questions about whether or not a particular accommodation would be appropriate for an employee, but really HR handling it is a really good approach. You've got the policy, you've got your accommodation process in place, you roll it out, and you keep lines of communication open for employee inquiries. All right, you've got a great policy, you've rolled it out, and then what happens? Some clients have all the luck, and it's been really easy for them. I think in Minnesota, it's something like 80% of all adults have been vaccinated. And so you may roll it out and you're not going to have too much trouble getting everybody vaccinated. But for others, as you can probably guess, it's not so simple. And so you're going to have employees request exemptions. And we're going to cover all these in detail, and they fall into three big categories. First one is those that have a disability or medical condition which contraindicates the vaccine. And what I mean by that is it means they can't get the vaccine or should not get the vaccine. Those with sincerely held religious beliefs against the vaccine. And then finally, those with personal political positions and beliefs. And sometimes they make it easy for you and say, this is my personal view. But other times they don't. So let's chat about them all. I'll be handling disability and medical exemptions. I'd say these are fairly unique. You will see them, but less often than the religious requests. And I think they're somewhat easier to handle than religious requests. And so what's the legal standard for when somebody says, I have a medical condition or a disability, which means I can't get the vaccine? Okay, it's under the law. Employers are required to provide an accommodation to those with disabilities to enable them to do the essential functions of their job unless it would cause us an undue hardship. Let's make that simpler in the COVID vaccine context. If an employee that has a disability or medical condition that prevents them from getting the vaccine, you would need to accommodate them unless it would cause an undue hardship. Let's talk about how that's going to work practically by going through the process. The employee requests an exemption and they fill out a form requesting a medical waiver. You've got a good form, and unless it's glaringly obvious there's some physical reason why they can't get the vaccine, you start a dialogue with the employee, and here's the most important part. I recommend that on nearly every single case, you request that a healthcare provider fill out a form justifying why the employee cannot or should not get vaccinated. This is really important. You want to make that healthcare provider stake their medical reputation on the employee's request, and you should make them state that this employee has a medical reason they can't or should get the vaccine. And, these do exist. People have allergies, or there's certain blood conditions that prevent people from getting the vaccine. So if you get credible and sufficient information from a healthcare provider that has the expertise to actually opine on this, then you would need to accommodate the employee unless it would cause an undue hardship or pose a direct threat to employee safety. In the disability context, this undue hardship standard is really high, much different than the religious standard that Anne's going to talk about. So it'll be like any other ADA matter. You're going to consider the cost of the accommodation, how big your company is, how rich your company is, but it's fairly difficult to show that it's an undue hardship in this context. Now, if you read the EEOC guidance on this type of exemption request for COVID vaccines, they focus on the health and safety aspect. And what they say is that you can't mandate vaccinations for employees with a disability unless you can show the employee poses a direct threat which cannot be eliminated or reduced by accommodation. It encourages you to do this two-part analysis with an individualized assessment. So first, you look and see whether the employee poses a direct threat to themselves or others if they don't vaccinate. And then you look at whether you can reduce that threat by a reasonable accommodation. I think this is overly complicated. This is just best practice, engaging in an interactive process and making a case-by-case determination about whether you can accommodate. So you look at whether the employee works remotely or whether they work near people. You look at whether the person could socially distance. You look at whether the person works with everybody else who's vaccinated, and you make that individualized assessment regarding undue hardship and health and safety. What the EEOC doesn't focus on is sort of non-safety reasons why you wouldn't be able to accommodate somebody. Say you've got an employee who's a salesperson and their biggest customer requires vaccination. That's a non-safety reason why you may not be able to accommodate somebody. If you lose your biggest customer, or you require somebody to travel across the country to service this customer because your person who has a medical exemption can't, that could constitute an undue hardship, potentially, even though there's that high standard. I think it's important to remember as you're going through this process with medical exemptions, we learn the lessons, or take the lessons we've learned rather, from past interactive processes. We're going to have really clear documentation. We're going to be engaging in the interactive process and communicating with people, with employees who request these exemptions. You're going to treat people equally and be consistent in your application of the exemptions you grant. And then, of course, since this is medical information, you're going to keep it confidential, all the while remembering undue hardship is going to be a tough standard to meet. And now I will pass it on to Anne, who's going to handle religious exemptions.
Let's focus for a bit on that second legally recognized exemption to mandatory vaccinations. And this exemption applies, as David mentioned, whether you're dealing with one of the federal mandates, if those ever come into play again, or whether you have a voluntary vaccination policy. The second exemption is the sincerely held religious belief. The basis for this exemption is actually found in Title VII, which I'm sure most of our audience has heard of, and the regulations and case law implementing that statute. With respect to religion, Title VII, like the Americans with Disabilities Act with respect to disability, prohibits discrimination based on religion, but also carries with it an affirmative obligation to reasonably accommodate an individual's religious beliefs and practices. So as with most areas of these human rights laws, there are layers upon layers of definitions. First, what is religion under Title VII? It's important to understand that the definition of religion under Title VII is really, really broad. It includes all aspects of religious observance and practice, as well as belief. And it can be an established religious belief under an established religion. It can be something that's uncommon. It can be something that's not inside an established religion. It can be a belief that is not part of a formal church or sect. And it can be a religious belief that is only held by a small number of people. One description of religious belief, which is somewhat helpful, is it talks about a sincere and meaningful belief that occupies a place in life of its possessor parallel to that filled by God. So religious beliefs include theistic beliefs, those based on a god or gods, as well as non-theistic beliefs, which would be moral or ethical beliefs as to what's right and wrong, but they have to be sincerely held with the strength of traditional religious conviction. So the flip side of this, which is also extremely important to remember, is that social, political, economic philosophies or opinions about whether a vaccine is safe or not safe are not religious beliefs, and they are not protected by Title VII. The next thing is, if you've got a religious belief, it has to be sincerely held. And this is really a matter of a credibility determination. Whether or not a religious belief is sincerely held is kind of a case-by-case focus. Factors, either alone or in combination, that may be considered as to whether this individual is credibly stating a sincerely held religious belief, include whether the employee has behaved in a manner inconsistent with that belief that they're now espousing, whether the accommodation they are seeking is a particularly desirable benefit for them that would likely be sought for non-religious reasons, secular reasons. The timing of the request, does the timing of the request render it suspect? So someone submits a request for an exemption based on a personal political belief or a discourse about the safety of or lack of safety of the vaccine. And when that doesn't work, they submit a request, perhaps with something copied from the internet, basing their request on a religious belief. The EEOC and courts have also stated that whether or not a belief is sincerely held, a religious belief is sincerely held, can be considered in light of any other circumstance that draws into play credibility of the particular individual's statement. In addition to stating a religious belief under the definitions of Title VII and demonstrating that it is sincerely held, the religious belief that is stated by the individual, of course, must also prohibit or prevent the person from taking the vaccination or complying with the specified protocol. For instance, a person can document a religious belief, and maybe some of you who are administering these policies have seen this, but the belief as documented does not prevent the person from taking the vaccine or complying with a specified protocol. An example is I've seen a number of exemption forms that talk about religious beliefs, certainly, but that religious belief has nothing really to do with the specific protocol for which they're seeking the exemption. And then the rest of the statement is about personal freedom, personal opinions about the vaccine or other protocols. Because the concepts of religious belief and sincerely held religious belief are so broad and so murky under Title VII, and sometimes employers are going to feel uncomfortable questioning the validity of these and going into the sort of legal minefield. Some of our clients are choosing to move beyond whether or not this is a sincerely stated religious belief to can we accommodate this person in their particular job? Can we accommodate them and allow them to continue in their position? Let's talk about undue hardship for purposes of a religious belief exemption. Title VII indicates that if the accommodation sought would create an undue hardship to the operations of the employer does not have to grant an accommodation, that the employer does not have to grant the request of the employees. The regulations and case law make clear that the undue hardship standard for religious belief, a religious belief exemption, is much, much lower than that for a religious accommodation request due to a medical reason or a disability. And I'll just give you some examples that will show you this. An accommodation may create an undue hardship if it compromises workplace safety, decreases workplace efficiency, infringes on the rights of other employees, or requires other employees to do more than their share of potentially burdensome work. This is definitely a lower standard than under the Americans with Disabilities Act. An undue hardship can be shown if the accommodation violates a collective bargaining agreement or rights under a seniority system. And it can be shown, undue hardship can be shown if there's more than a de minimis cost to the organization. Very, very different than under the Americans with Disabilities Act. The one thing is that the undue hardship that the employer is relying upon must be genuine. It can't be speculative. So what constitutes undue hardship? Seems to me that by the plain wording of the statute and the regulations and what the EEOC has talked about, undue hardship for an employer in terms of a religious exemption should not be that difficult to prove. And it's based on a lot of things that David has already talked about. the employer can rely on the health and safety consequences to the workforce, to the employee, to other individuals in the workplace. They can rely on the science of the dangers of COVID-19, the widespread community issues related to that, the uncanny ability of this virus to morph and spread, and most recently, the emergence of the Delta and the Omicron variants. Federal and state mandates throughout the country have been proliferating. The employer can rely on all of this, and all in the context of the nature of this individual's position, the nature of the work, the nature of the work environment, the cost to the employer, the number of exemptions the employer can afford to grant due to labor shortages and other things. Health and safety concerns as a basis for an undue hardship argument are particularly strong, of course, in the healthcare settings and direct patient care settings, but also in, as David mentioned, in direct client service settings, manufacturing operations where social distancing and other protocols might be difficult to maintain because of the nature of the work or the work environment, the retail and hospitality industry, et cetera. In the end, while the undue hardship threshold for religious exemption is much lower than under the Americans with Disabilities Act, we do recognize that we are in a bit of an uncharted territory here. Until we have a critical mass of agency decisions and court decisions, we will not really know where the courts and agencies will land. But our clients are and have been and will continue to make these decisions based on the best information that we have. A few miscellaneous items, David has already touched on some of these. It is extremely important in all of this that you make sure you follow your process and your policy, particularly if you are later subject to one of these mandates, because as I mentioned, there are bells and whistles in each of those mandates that are a little are specific to those mandates. And in doing so, focus on your documentation and the quality of your documentation. So if someone has requested an exemption, make sure that you've got, as David mentioned, is going to request, make sure that you've got uniform exemption forms that ask direct questions about the various standards that must be met. We strongly advise you to work with counsel to create these forms. I, for one, and I'm sure that many of my colleagues have been sent forms that have been pulled up from the internet, and sometimes they're a good start, sometimes they're not even a good start. But in documenting your ultimate decision about whether you're going to grant or not grant an exemption and about whether you're going to grant or not grant a reasonable accommodation, focus on who your audience is. Obviously, your audience is the employee. Your audience is also your workplace at large because employees talk to each other. But your audience is also the agency or the court or the jury or whoever is going to be looking at this down the road. And just a few thoughts. I would not concede that somebody has a disability or a sincerely held religious belief. There's a way to phrase it such that you're moving on to the reasonable accommodation analysis so that you leave this argument open. Some instances you're going to have to concede it, but in most responses to employees, you don't have to. When you do decide, if you decide that an accommodation is possible, think about making that temporary. Say that you're going to reevaluate it in 30, 60, 90 days, leaving yourself some flexibility because things can and do change. If it's been determined that the person is going to be granted an exemption, that they are entitled to an exemption, but it would result in an undue hardship, as David has outlined, lay out, the health and safety reasons for the vaccine mandate, lay out the details of why this is an undue hardship, the health and safety, the science, the nature of the job, the level of community spread, the number of cases, the number of deaths, et cetera, all in light of the nature of the position. Another point is to try to make sure that decisions with regard to exemptions are made centrally rather than on an ad hoc basis so that there is consistency. As we all know in the employment law area, lack of consistency will result in discrimination claims over and above claims for failure to accommodate. Just a couple of comments on situations where individuals are requesting exemptions from vaccination policies and other protocols due to personal or political positions and beliefs. Many of us, I'm sure, have seen these referencing First Amendment rights, referencing mistrust in the science, mistrust in the government, fear regarding whether or not the shot is adequately researched, etc. You are not required, of course, to grant an exemption for any of these reasons. However, if you wish to proceed and consider granting some kind of an exemption or exception for these folks, make sure that you understand that in doing that, you are going to create a precedent for what you're doing with employees that have requested an exemption due to disability or due to religious beliefs. This is, most of my clients have been using these political personal requests as an opportunity to talk about the reasons why the policies are in, to talk about various resources that are available to allay some of the employees' fears, etc. With that, I will turn the microphone over to David.
Thanks, Sam. We're getting some great questions, and so I want to cover these slides a little bit quicker as we've sort of hammered home the points before, and so I do encourage you to submit other questions. We want to leave plenty of time at the end. As far as potential accommodations go, I think there's sort of a misconception that if somebody won't get vaccinated, that we have to fire them. It's always going to lead to massive and painful layoffs. That's not true. We want to be flexible. We want to work within the confines of the law. And so we've listed some potential accommodations there. And of course, you're going to engage in that interactive process when legally required to, and you're going to document all the things that you considered. I think there are two really key points that lead to a successful vaccination program, and I think they're somewhat contradictory. The first one is that we want to go in with an open mind. If we go in thinking that this is going to be horrible, nobody's vaccinated, we're going to have to fire a lot of people, I think that can sort of create trouble from the beginning. We want to be flexible, like I just said, and we're not going to prejudge the process and assume it's going to be horrible. However, the second point that leads to a successful vaccination program is we do want to be prepared. We want to be prepared for potential issues so that when they arise, we're better equipped to deal with it. So we've identified some potential outcomes, and happy to talk more about them in the Q&A. But you see, what if an employee doesn't qualify for an exemption under the law? Well, like Ann said, it's probably good practice to deny it in most instances. It's going to make it really, really hard if you wanted to deny an accommodation for somebody who does have a sincerely held religious belief or a medical condition, because you're saying it's an undue hardship when you're turning around and granting accommodations that you're not legally required to. What if an employee qualifies for an exemption, but accommodation is not possible or creates an undue hardship? Document. When that arises, should you terminate the employee? Put them on indefinite unpaid leave? I think there's pros and cons to both approaches. One pro is that an accommodation, there's some analysis, and I believe one court decision that indicates unpaid leave is an accommodation. For some employees, they may be able to keep health benefits for a period of time, even while on leave. but a big con is that it just kicks the can down the road. But no matter what, when you're thinking about these outcomes for each employee, you're going to take them on a case-by-case basis and consider how well you've documented, what type of request it is, and the overall strength of your legal position before making a decision. We're going to bring it home. Takeaways. Get legal involved. Make sure you're aware of all the laws that might be at play, whether they're state or federal. Have a dynamite written policy. Have clear communication and open dialogue. Identify folks that people can talk to if they have questions. Identify, or rather evaluate, exemptions on an individual basis, and document. All right, we've got some great questions, and so I'm going to pose them to whoever wants to answer them. I'm really excited about these because I actually think I know the answers to some. Okay, somebody asks, I'm not going to identify them. For a religious exemption, is a signature of a clergy person required on the form? An employee has informed me her lawyer says it's not. Please advise. Anne, could you advise on that?
Absolutely. You do not even, a clergy member does not even have to exist to support the employee's religious beliefs. So no, you do not need to have a clergy member sign the form. You can always ask for clarification from the employee of their religious belief, and the employee can offer to provide information from a clergy member, and they often will. If they are part of an organized religion. But no, it is not required.
Yeah, I totally agree with that. I've had some clients who are Catholics, and they've gotten a little annoyed when their employees request a religious exemption because they say they're Catholic, and the client has said to me, well, the Pope says it's okay. And I get it. I'm the most pro-vax guy you'll ever meet. I'm also Jewish. And what I tell the client is there's lots of things that chief rabbi says that I don't agree with either. So no, a clergy person doesn't need to exist, like Anne said. All right, here's another question.
David makes an excellent point on the religious exemption in general. You can have a sincerely held religious belief as a Catholic or as a Jew or a member of any other religious faith that contradicts what the actual rabbi, the Pope, the leaders of the church say.
All right, this is a really good one because I hear this all the time. So, unfortunately, we have an employee who submitted a religious exemption. The reasons for the exemption seem appropriate. However, she told her supervisor she submitted her information to avoid being vaccinated. Should we deny her request because of what she shared with her supervisor? Well, I'll weigh in, and then I want to turn it over to the other folks. I think that goes to the credibility of their sincere religious beliefs. And so what I would recommend is you may want to go to this employee and say, your supervisor reports that you told them that you submitted the information solely to avoid being vaccinated. Is that true? And see what they say. But if it goes to that credibility, then you certainly want to document. You submitted a request for a religious form and you verified that it was the truth. You later admitted you told your supervisor that it was just a ruse. And so as a result, we don't think this is a sincerely held religious belief. Anne, any comments on that, or Olivia or Sean?
Yeah, as David is mentioning it depends a lot on what the actual interaction was with the supervisor. And what it also matters what the employee then tells us about that interaction, because you have, two individuals that may have a different view of what happened in that conversation. But it absolutely, as the question suggests, raises a question about credibility that you can, if you wish, to look into.
Here's another one. It says if someone's against, is someone being against Western medicine appropriate, or can we ask for more info? I didn't touch on this in the medical section. Well, I did mention it, but I've had inquiries where somebody requests a medical exemption and the healthcare provider seems to be not a doctor, not a nurse practitioner, not qualified to opine on the medical reasons why somebody should get not get a vaccine. And under the ADA, you're absolutely, that would be considered insufficient information. And so you would tell the employee in that case, perhaps they've got a different provider that says, we're against Western medicine. Then you would explain to that employee why that is not sufficient to justify a medical exemption and ask them to go to a healthcare provider. Anne, thoughts on that?
I agree, totally.
Let's see. They're coming in fast and furious. How heavily would the factor of length of a sincerely held relief be considered? Is there a length of time a person should meet to demonstrate sincerity? What if they joined a Facebook group of agnostics who refuse the vaccine, or based on a concern that the medical system is grounded in systemic racism? So it's really talking about that credibility aspect. I love Facebook, by the way. You can find out lots of things about your employees. I wouldn't recommend looking, but it's tempting.
You know, as a practical matter, a sincerely held religious belief does not need to be held for any length of time. Of course, it bolsters an individual's credibility if they have held this belief for a long period of time. But the glitch there is that beliefs can change. And our First Amendment protections for religious freedom, the freedom to believe and the freedom not to believe, are fairly broad. So you'd have to look at that fairly carefully. It sounds like it's, I would have to see the exemption form and what they're saying, but it sounds like that they aren't coming up with a sincerely held religious belief. But just because your belief has changed doesn't negate that it is sincerely held.
Agreed. Someone asks, would an employee need to formally fill out an exemption form if they just want to choose to submit to weekly testing and masking instead of getting the vaccine? Or is the exemption form necessary for when someone doesn't want to agree to either getting vaccinated or getting tested weekly and masking? Well, let's assume OSHA's in play. Do they have to fill out an exemption form just to mask and test?
Well, sure, David, I can take that one. I think in that case, it depends what policy you choose. Under the OSHA ETS, you have the option to either implement a mandatory vaccination policy or a policy that allows an employee to choose between mandatory vaccination and testing and masking. So if you had a policy that allows the employee to choose between the two, in that case, the employee would need an exemption form. However, if you had a mandatory vaccination policy that didn't allow an employee to choose between testing and vaccination or testing and masking, testing and masking might be a reasonable accommodation, and you should go through the exemption form and the interactive process that we've talked about earlier in the presentation.
All right, here's Sean gets to answer some questions. Our organization delivers ICF/IDD services covered by CMS and HCBS services covered by OSHA. Because staff work everywhere, train everywhere, meet all the time together, we've just decided to follow the CMS mandate because we can't separate out or wall off staff. And it's the most stringent mandate. Are we okay? Also, is testing a required accommodation for approved religious exemptions under the CMS mandate? Well, perhaps Sean has disappeared.
Oh, I'm sorry. I was on mute. Here I am. Can you hear me now?
Yes.
Okay. So with respect to the first question, we've definitely had this where an organization kind of has multiple, prongs, some of which would seem clearly covered by the CMS mandate and others not. And it's hard to distinguish between the two, and there's overlap and what to do. And I think the approach of just uniformly applying the mandate is certainly a valid one. And just remember that even if the CMS mandate is struck down, I mean, that you're free to voluntarily have your own mandate. So even if you apply it to the staff that you're required to apply it to, you could also apply it to other staff. But I guess to the extent that the mandate struck down, then it will not be preempting any applicable state laws. So you will then need to pay more attention to if you're in a state that maybe requires exemptions for personal political beliefs, whereas the CMS mandate does not, then you would need to maybe factor that in. So you might need to pay more attention to state law is the answer, but in general, applying the CMS mandate to your whole organization seems like a good approach. And then, is testing a required accommodation for religious exemptions under the CMS mandate? And we don't have an answer. We don't have an answer on that. We have the statement in the regulation that additional precautions to protect patients is required, and kind of what you, depending on the setting and what you decide is appropriate, whether it's testing and masking or distancing or separation from patients, there's no set rule there.
Thanks, Sean. There are a lot of different licensed health providers of care, someone asks, naturopath, DO, LAC, DAOM, etc. Is there a set standard for what is acceptable for providers and what isn't? So under the FMLA, there actually is a definition of what a healthcare provider would be. We don't have that as far as I know under the ADA, but the person has to be qualified to provide the opinion that they're providing. And oftentimes, I think I'm not passing judgment, but here's a theoretical situation. If a naturopath opines that somebody's got a serious cardiac condition that prevents the person from getting the vaccine, then a lot of the time, that's not somebody who has a level of expertise that would qualify them to give sufficient information, particularly if they're not licensed or there is no licensure for a naturopath in the state. I think DOs are a completely different story. To that end, you can ask for You can ask for employees to go to a healthcare provider of your choice under the ADA, but you'd have to pay for it. All right, I like this one. Somebody asks, we've got an employee that says she refuses to do anything until she has everything in writing. We've got 2 minutes, Anne. What do you do with that type of employee?
She refuses to do what if it's not in writing?
All right, I'm gonna role play. She says, I'm not getting vaccinated or providing you a list of accommodations I want unless you tell me in writing exactly what you're going to do.
I would gently let the employee know that here is the policy. I would explain what the policy is and give her an opportunity to comply or to submit an exemption if that's what our policy required. And ultimately, if the employee, digs in her heels, she's not in compliance with our policy. So then you move to potential outcomes. Of course, none of our clients have employees that would do such a thing, right?
Yeah, right. And of course, everything Ann says, you do that in writing. And of course, you can document and hit them over the head. We're really concerned as to why you're unwilling to provide this. We're doing this to keep people safe, and this is a safe and effective vaccine. And boy, we're confused by this. Let's see. I think we have one more. If someone's on a leave, can they claim unemployment in Minnesota? That's a great question. If you've placed them on unpaid leave. I don't actually know the answer for Minnesota. I do know, and so I'll turn it over to Anne or Olivia or Sean, but I do know that in some states they've passed laws which if you're terminated for refusing to be vaccinated, you automatically qualify for unemployment. Any thoughts about Minnesota?
I don't actually know whether unemployment would kick in for Minnesota. I mean, if the person is out of work due to failure to follow a policy, I think on that one, if we can identify who is asked the question, we can follow up with an email later.
Great. Well, we're right at 1 minute or 1 hour, 15 minutes. I want to thank everybody for participating and asking such great questions. This is a challenging topic. It's confusing, but we're always available to help get you a great mandate, vaccine testing policy, whatever you want, and deal with those employees that request everything in writing. We're here to help. So thank you very much and have a great rest of your week.